Hello and good morning friends, welcome to the CEC-UGC live lecture. Dear friends, under our series Trademarks and Copyrights, today we would be going to talk on shape trademarks, as well as we would be discussing on grounds for refusal of registration for shape trademarks. And for this discussion we have once again within our studios Mr. Ashwani Sewal. Mr. Ashwani Sewal is Assistant Professor in IP and Data Security Laws, Faculty of Law, University of Delhi. So dear friends, let's welcome our guest Mr. Ashwani Sewal and let's try to understand more and more about shape trademarks. Hello sir, welcome to the EduSet lecture.
Thank you. Good morning viewers. We have been discussing and deliberating a lot on some grounds for refusal of registration covered under section 9 of the Trademarks Act 1999. So far we have dealt with the section 9.1 and 9.2. We have to today discuss section 9.3, especially the prohibitions covered under section 9.3 on certain non-conventional kinds of marks which are called shape trademarks. So our modus operandi for today's discourse would be in two trajectories. In one component or in one trajectory I would be telling you what shape trademark is all about. Then in the next hand or on the next aspect I will be telling you the grounds for refusal of registration of a shape trademark. I mean, some prohibitions are covered under section 9.3 which are called the grounds for refusal of registration of a trademark. And when we talk about those grounds for refusal of registration of trademark, we see that section 9.3 restricts protection of trademarks on the basis of functionality, on the basis of technicality of those marks. We will discuss those things in detail, but first we need to understand what shape trademarks are all about. Well, friends, with this Trademarks Act 1999, which became operative in the year 2003, we have got shape trademarks, and you see it has become easier with this act and its operation that a shape can be given a trademark. The shape of a product itself can be given a trademark. The shape of any thing can be given a trademark. Service cannot come under it because there is no such prohibition categorically mentioned in the provision. But what one can understand and make out that on services a shape trademark is not viable, is not possible. But for the goods, a shape trademark is possible, is viable. And with the new Act of 1999, and especially with its operation in the year 2003 when it came into the being, you see a shape can be given a trademark. There are certain examples to make you understand which I would like to utter in the very beginning. Say for example, we see the shape of bottles in the market, the shape of a Pepsi bottle, friends, the shape of a Coca-Cola bottle, the shapes itself of these bottles, or say for example the bottle of a Pepsi or of Coca-Cola is a registered trademark for Coca-Cola. Well, it's sounding very interesting that a shape itself has become a trademark. There are certain restrictions and implications and limitations attached to it, but it can be given a trademark protection. And this pattern of giving and granting a shape trademark or a trademark to a shape is a non-conventional kind of a trademark. We see earlier, we have seen so many trademarks, especially the trademark to be given to a word, to a letter, to a symbol, logo, device, numeral, figure, letter. That is possible and it can be given. But when it comes to non-conventional things, especially you see shape, it arises the curiosity of a person, can a shape be given a trademark? Yes, it can be given a trademark, and it is a kind of a non-conventional trademark. There are some more trademarks which are called non-conventional trademarks apart from shape. To name a few, color combinations can also be given a trademark. Sound, you see, can also be given a trademark. Smell can also be given a trademark. I mean, the thing that is the prerequisite for getting the trademark protection is its being distinctive in character. If the shape has become distinctive in character, is establishing the distinctiveness, then a shape can be given a trademark protection without any hesitation. So is the case of color combinations, so is the case of packaging, so is the case of smell, so is the case of sound. All these non-conventional marks can be given a trademark protection on different goods or services if, you see, they prove the distinctiveness required, if they prove the distinctive character. And to my understanding, all my viewers understand now what distinctive character means. Well, friends, distinctive character here in a nutshell means distinctive character, in short or precisely, you see, signifies the capacity of the trademark to distinguish the goods of one enterprise from the goods of another enterprise. So if the shape performs this function, if the shape is such which can easily distinguish the goods from other goods available in the market, if the Coca-Cola bottle shape, if the Pepsi bottle shape itself can make the buyer understand, the consumer understand that this bottle is a bottle of Pepsi and its origin is PepsiCo, then you see it serves its purpose and it can be called and termed as having distinctive character. And if it does have the distinctive character, it can be given a trademark protection without any hesitation, because we have this kind of a legislative framework where it is allowed. Under the 1999 Act, in the Indian context, the trademark law allows the shape trademark to be given to a shape. But there are, friends, some prohibitions attached to a shape trademark to be given a protection by purview of the Trademarks Act 1999. So those prohibitions are to be taken into the consideration. They are to be kept into the mind while applying for the protection of a shape as a trademark by the applicant. And so is the case of the trademark board. They have to see whether this shape can be granted a trademark protection or not. Well, friends, as I said that these marks are called non-conventional marks. Conventional marks are very simple, I mean the marks in the form of word, letter, numeral, but these are non-conventional. So they require some extra caution and care on the part of the applicant applying for obtaining the trademark and on the part of the trademark board conferring the registration on that particular non-conventional mark. Well, though as far as the law relating to distinctiveness is concerned and its interpretation is concerned, the same law remains applicable even in the case of shape trademarks. But the threshold in the case of shape trademarks is little high. I mean, one needs to show that the consumer, the buyer, the end user of the goods can easily make out the source and origin of the goods from the shape of the product itself, from the shape of the thing itself. If that gets proved, if that gets established, then that shape can be given a trademark protection and it involves a distinctive character. So fulfilling the requirement of distinctiveness is to be taken care of, has to be taken care of by the applicant for obtaining the shape as a trademark for his goods. In the case of services, I haven't seen any shape trademark put on the services. I rarely find any such example to be quoted here. So I abstain to quote any example or a vague example for services. For goods, there are many examples where shape has been granted a trademark protection. Well, the further elaboration for understanding the concept of distinctiveness for shape trademarks we need to understand that if the shape itself is able to depart from the common norm, if the shape itself is able to indicate the source or origin, then that shape qualifies to be called a distinctive shape and can be given a trademark protection easily. Well friends, kindly keep this test in the case of shape trademarks into your mind, that if your proposed shape is sufficient enough to indicate the source and origin of the goods merely with the application of that shape on those goods, or if that is able to depart from the common norm and custom, then in that case it establishes as a distinctive shape and that can be given a trademark protection. Though in the marketplace it is not that easy to establish the distinctiveness or to acquire the distinctiveness over a shape, it is rarely seen that in the case of acquired distinctiveness, there hardly come any example of a shape trademark. But we see that in the cases of inherent shapes, we rarely find any example. Acquired distinctiveness may be there in a case of a shape trademark, but this inherent distinctiveness is not able to spot and is not able to find in the cases of the shape trademark. We rarely find any inherent distinctiveness in the shapes to fulfill the qualification of distinctive character, to fulfill the qualification of indicating the source or origin. If one shape is so popular, has become renowned and has become very common into the eyes of the consumers, and if they recognize with that shape the origin of that particular goods or the source of those goods, then that shape is very potent enough to be called a distinctive shape and to be called a shape having a distinctive character, and it can be granted a trademark protection right away. Well, as I said that there can be several examples of a shape trademark on goods, not for services. It is only possible for goods, not for services. A shape can be given a trademark protection for goods, not for services. What does it mean, friends? That there cannot be any trademark in the form of a shape trademark which can be used for services, but for goods there can be several such trademarks which are shape trademarks on the goods. For example, you see the shape of a Coca-Cola bottle on the goods which are beverages in question, the shape of a Pepsi bottle, the shape of a iPod, the shape of a razor of Philips. These are some of the examples which are very common examples to understand the shape trademark. There comes a very good quality product of Philips, a rotary razor. That razor has got a peculiar shape, and because of its shape one can easily identify that Philips is a manufacturer of these kinds of razors or razors of this shape. That is how this shape trademark functions and becomes a pertinent trademark to be used in the marketplace. Well friends, as I promised in the very beginning that there are some objections to shape trademarks to be given a registration, and some examples are there where we have find that the shape as such is qualified on terms of substantive requirements for obtaining the trademark registration, but it gets hit by some of the prohibitions contained under section 9(3), which are called grounds for refusal of registration of the shape trademarks, and we have a separate section altogether for dealing with the grounds for refusal of registration of a shape trademark. Let us see those grounds one by one. As I told you that those grounds are covered under section 9(3) of the Trademarks Act 1999. Well friends, if you see the language of section 9(3), it reads that the shape of goods which results from the nature of the goods themselves, it shall not be registered as a trademark. the shape of goods which results from the nature of the goods themselves. There are some rationale and some logics behind the exclusion of these kinds of shapes to be given a trademark protection. We have to identify those logics and rationale behind the exclusion or ousting of these particular shapes to be given a trademark registration. If we go further and see the language of section 9(3)(b), it reads the shape of goods which is necessary to obtain a technical result. So a shape which is necessary to obtain a technical result, it shall not be registered. There is a different rationale available for the exclusion. And the third and the last one when it comes to shape trademarks is 9(3)(c), which reads the shape which gives substantial value to the goods shall not be registered. Well friends, if you see all these prohibitions covered under section 9(3) on your screen, what I find from the prima facie reading of section 9(3) on the screen, I find that the two prohibitions covered under 9(3)(a) and (b) are quite logical and restricted in their implication and application. But the third prohibition given under 9(3) in the form of 9(3)(c) is a prohibition which looks vague, which looks unclear from its reading. If you see that 9(3)(c), it reads that any shape which gives substantial value to the goods. So it's too wide a reading or too wide an interpretation can be given to 9(3)(c) vis-a-vis to the previous two prohibitions covered under 9(3)(a) and (b). Let us take up all these prohibitions one by one in a threadbare manner. If we come to 9(3)(a), as I told, that it reads the shape of goods which results from the nature of the goods themselves. Well, I would urge to all my viewers and listeners to kindly apply their mind and think before straight away jumping to the conclusion as to why that kind of a shape has been excluded to be given a trademark protection, the shape which results from the nature of the goods themselves. Well friends, to be quite logical and by applying the common sense, I understand and I find that this kind of a shape is restricted and precluded to be given a trademark protection because it has been kept open for everyone to use it. I mean the shape which results from the nature of the goods themselves. That shape should not be given in the form of a monopoly to one individual, in the form of a trademark proprietorship to one individual. The shape which results from the nature of the goods themselves should be kept open to be used by everyone. I mean those who are interested to use it. I have one example to make you understand. See, the shape of a wheel results from the nature of the goods themselves. Wheel cannot be or cannot afford to be even of any other shape except round shape. So the round shape of a wheel is such a shape which results from the nature of the goods themselves. So if somebody tries to register round shape of a wheel as a trademark for his goods which are wheel in that case, he won't be ever able to get the registration of a trademark, as it is restricted and prohibited by purview of section 9(3)(a), which reads that any shape, and in this instance the shape is round shape of a wheel. This round shape of a wheel is because of the nature of the goods themselves. A shape of a wheel can never be of any other shape. It will always be a round, otherwise it will not function, it will not be efficacious. So if anyone aspires to obtain that kind of a shape as a trademark for his goods, he won't be able to get it. So there can be several examples to make you understand that any shape which results from the nature of the goods themselves should not be given a trademark protection. The rationale here, as I told, is to keep free basic shapes to be availed by public or used by public. is to keep free basic shape of the goods that should be available for use by public. If a shape of a round wheel, that is a circle shape, if is given to one individual or to one entity, then others would be deprived of using it. So this restriction in the form of 9(3)(a), friends, has been put here with this premise or with this rationale that some free basic shapes should be kept open, should be left open, and they will not be given in the form of a monopoly to one individual or to one entity. Otherwise, you see, others will be deprived of using those shapes. And you see, as you have understood from this discourse, that shape as trademarks are allowed and can be given. Well, if we go ahead with the discussion or analysis of 9(3)(b), friends, I have told you that this prohibition covered under 9(3)(b) is again a prohibition premised on some rationale, is again a prohibition which is premised on some logic. Let us see what this 9(3)(b) reads. It says, the shape of goods which is necessary to obtain a technical result. That shape cannot be given a registration. That kind of a shape shall not be registered by the trademark registrar. Well, friends, this is very easy to comprehend for all my viewers, that any shape which is resulting into a technical function or which is necessary to obtain a technical result. Let us take the similar example, the example that I gave for the earlier clause, the shape of a wheel, round shape of a wheel. If the wheel is not of a round shape, then that wheel will not work efficaciously. That wheel will not function properly, will not serve the purpose at all. So that round shape of a wheel is required, is necessary for obtaining a technical result of those goods which are wheel in question. So if the wheel is of not round shape, it will not be of any use. Only round shaped wheels can lead to a technical result. So any shape which is necessary to obtain, a technical result, that shall not be registered, because it has to be kept open to be used by everybody or by all. No one individual should be given a proprietorship or a monopoly on that particular shape by purview of the trademark law. If you see the rationale behind the exclusion, this shape of good which is necessary to obtain a technical result is basically to prevent trademark protection on technical solutions or functional characteristics of the product. See, there are some shapes which are necessary for the functioning of the products, for the working of the goods. If that shape itself gets registered, and after the registration one gets the monopoly over that, only he or she will be able to continue to use that shape, others will be deprived of it. He does get a right to exclude others to make use of that shape. So in that scenario, you see, that shape will be owned by one individual and others will never be able to use it for its working, for the working of those goods, for the functionality of those goods. So any shape which is necessary for the functionality of goods, which is necessary for the working of the goods, that shall not be registered as per section 9(3)(b). Well, friends, one more thing that is coming to my mind at this juncture, that shape as a trademark, it is a reiteration of my earlier point, that shape as a trademark is allowed to be given a registration, and one can make use of a shape as a trademark even without getting it registered. Both ways it is protected. In the case of the registered trademark, it is protected by the Trademarks Act 1999, by some statutory remedies available through the 1999 Act. In the case of non-registered shape trademark, that shape is also protected not by purview of the Trademarks Act 1999, but by purview of the common law remedy in the form of passing off. I mean, the user of a shape trademark can any time initiate the action of passing off against the infringer, against the wrongdoer. Friends, there comes a very ticklish question in my mind when we discuss 9.3 that reads, what if the shape has both technical and non-technical features? Well, the answer to this question has been offered by one of the case laws in UK, where it was decided and where it was deliberated that there can be a shape having both the things in it. I mean, it may have both the features in it. It may have a technical functionality involved in it. It may have non-technical features involved in it. So what about that kind of a shape which involves both these technical and non-technical features involved in it? Can that also be prohibited by purview of 9.3b, or will that also be restricted to be given a trademark registration? So on this question, friends, the court deliberated and found that in the case of such trademarks which are involving both kinds of features, technical as well as non-technical features, it has to be seen that what are its substantial and essential features. If its essential features are technical features, then that trademark shall not be registered. If its essential and prominent features are non-technical features, then it may be registered. So what we understand in nutshell, that to grant a trademark protection to a shape, what is to be seen? It is to be seen whether this trademark proposed to be given a registration is necessary to obtain a technical result or not. If that is necessary to obtain a technical result, it shall not be given a registration. If it is not, then it can be given a registration. The only thing that has to be kept in mind, and the only ticklish part and the complicated part that is to be kept in mind, is about those shape trademarks which involves both kinds of features in it, technical as well as non-technical features. In that case, you see, the substantial features of the mark are to be taken into the consideration, and on the basis of those substantial features of the mark, it is to be decided whether it involves more technical functions and less non-technical functions. If it involves more technical functions, no registration will take place, will not happen. If it involves more non-technical functions or features, it shall be registered as a trademark. The third prohibition, the last prohibition, friends, given under or covered under 9.3c, which I told is little unclear, is wide and is vague, because it says the shape which gives substantial value to the goods shall not be registered. Well, I posit that every shape, be it a shape which is because of the nature of the goods themselves, or a shape which results or is necessary to obtain a technical result, every shape which is giving a aesthetic value to the goods, every shape, to my understanding, friends, gives substantial value to the goods. We have a discussion on this aspect of 9.3c in a very elaborate manner in the next session, friends. Thank you very much.
Thank you. Thank you.
this session, friends, we are going to see the last prohibition on shape trademarks given and provided under section 9(3)(c) of the Trademarks Act 1999. This prohibition is an unclear prohibition, is a very vague and wide prohibition if it is compared with earlier two prohibitions covered under section 9(3)(a) and B. As the reading of this 9(3)(c) gives unclear understanding to a reader, because you see, every shape gives us some substantial value to the goods, be it a shape which is because of the nature of the goods themselves, be it is a shape which is necessary to obtain a technical result, be it a shape which gives a aesthetic appearance to the goods. So every shape has something or the other to add to the quality of the goods, or say to enhance the quality of the goods, to give the substantial value to the goods. So when we read section 9(3)(c) as on your screen, it gives an unclear understanding. It says that any shape which gives substantial value to the goods shall not be registered, or you see, it should not be registered. Well, when one tries to interpret or decipher this unclear language, then the best possible interpretation, the widest possible interpretation of this unclear language is to understand that this substantial value of the goods in this context is to be construed just to attribute to its shape. I mean, any value that has been attributed to the shape of the goods, if that value has been given to the shape of the goods, then it shall not be registered. Well, the idea, friends, here is to demarcate or to distinguish between two separate kinds of intellectual properties. By purview of section 9(3)(c) prohibition, the trademark law tries to strike a balance or tries to distinguish between the design rights through the Designs Act and the Trademarks Act through the Trademarks Act. Well, there are some common subject matters for both these separate kinds of intellectual properties. Trademark and design law share some common subject matter. So to prevent any interface, or say to prevent any conflict into the applicability of the Design Act on the one hand and the Trademarks Act on the other hand, this section 9(3)(c) prohibition comes to rescue and can be availed or can be used, because it says that any shape of a good which gives a substantial value to the goods, it shall not be registered. And substantial value here has to be restricted only to what? Only to the thing which is attributable to the shape of the goods. Well, friends, as I told, that idea here is to preclude monopoly to any shape which can be protected under the Designs Act. And what all is protected under the Designs Act, that have not been covered by me yet, but for your superficial understanding and preliminary understanding, let me tell you, under the Designs Act in India, some shapes, configurations, figures are allowed to be registered as the designs. Well, when the shapes are registered as designs, and on the other hand, in the case of the trademark law, the shapes are also eligible to be given a trademark protection, the scope of conflict and contradiction remains high, or it remains present. So to tackle this contradiction or to tackle this scope of contradiction, the law provides a solution in the form of 9(3)(c), as well as some of the provisions of the Designs Act also preclude trademark registration to be given to certain shapes, especially the shapes which are necessary to obtain a technical result cannot be given a design protection. The shapes which are the result of the nature of the goods themselves, they cannot be given the trademark protection as well as the design protection by the Designs Act. But here you see, by purview of 9(3)(c), the law says and tries to say that any shape which gives a substantial value to the goods, that shall not be registered. So what can be the possible examples, friends? To my understanding, the possible examples to be quoted and to be given for the purpose of understanding section 9(3)(c) are the examples of jewelry ornaments. You see, the shape of ornaments, the shape of jewelry is just to adorn the jewelry, is to beautify the jewelry, or say to give the substantial value to the goods. That's it, not more than that. Because jewelry is not required to be of some shape which is because of the nature of the goods themselves. The jewelry or the ornaments are not supposed to be such which are necessary to obtain a technical result. So those earlier two preceding prohibitions will not apply and cannot be invoked for restricting the shape as a trademark on the goods. But for jewelry and ornaments, this third prohibition may be invoked and can be applied, which says any shape which gives a substantial value to the goods. So no jeweler, you see, no jeweler can own a trademark on one peculiar shape of an ornament. He cannot own a trademark on the shape given by him to the ornament, because that shape gives a substantial value to the goods, and if it is giving a substantial value to the goods, it will never be able to obtain a trademark protection, as it is precluded to be given, prohibited to be given by purview of 9(3)(c). Well, friends, it can be given a design protection. There is no denial to that, because design law tackles those things in a very different manner. The qualifications for obtaining the design protection are altogether different. The subject matter of the design may be similar with the trademark and with the shape trademarks especially in particular, but the rest of the subject matter sorry, of the design protection is different. So what is to be taken into the mind here? The design law on the one hand and the trademark law on the other hand are different IPs altogether, tackling the different subject matters altogether, providing a different qualifications altogether, and that is how we understand. Though there is a conflict in the shape trademark thing, which gets kind of neutralized, which gets balanced by the purview of 9(3)(c) as well as some of the provisions of the Designs Act. Moving ahead, friends, let us first of all understand at this juncture the distinction or the difference between trademark and designs, and their you see functions especially. The trademark law has got a very different kind of a function in comparison with the design law, and especially the trademark as such has got a different function in comparison with the design. In one of the cases, you see, the judge of Delhi High Court clarified the fundamental distinction between a trademark and a design. What is that fundamental distinction, friends? As highlighted in this case law of Delhi High Court, which to my understanding must be clear to all my viewers, it reads as follows. The trademarks has got a function of signaling to the mind the source or identity of the producer, manufacturer of the article, whereas a design appeals to the eye and attracts the consumer and purchaser. In short, you can say designs are for aesthetic appearance or for aesthetic functions. Trademarks are for indicating the source or for signaling to the mind of the consumer the origin of the products. That's the function of the trademark, and this got clearly demarcated in this case law decided by Delhi High Court in year 2004, mentioning categorically that trademarks are for purpose of identifying the source, not for the purposes of giving a aesthetic appearance to the articles, whereas the design is for the purpose of giving a aesthetic appearance. So the functions are altogether different. Moreover, when it comes to the distinction between the design law and the trademark law, you see, in both the term varies. In the case of the trademark law, the term for the protection of the trademark is in perpetuity. It remains forever with the person, subject to the renewal fee paid by the entity or by the person concerned. If he or she keeps the renewal fee paid updated, then the trademark can be owned by that person perpetually. There does not come end to the trademark protection. But on the other hand, you see, the design right is a limited term right. It is owned by an individual only for 10 years, extendable maximum for another 5 years. So in totality, 15 years term is there for the design subject matter. So let us come back to our core issue of our today's discussion, shape trademarks. You see, what if there is a shape which is registrable under designs law as well as under the trademarks law? The producer, the creator of that shape, the owner of that shape will always try to fetch the trademark protection instead of getting the limited term of 15 years through designs law, because the trademark remains in perpetuity, it remains with the person forever. It does not come to an end. So see, there lies a scope of contradiction here when one tries to invoke the trademark law in aspiration of having a more protection. He can be restricted to be granted or conferred the registration on that shape as a trademark by purview of section 9(3)(c), which we have just discussed. So that is the purport and function and the rationale of incorporating section 9(3) and the prohibitions covered under section 9(3). Well friends, I believe all of you have understood that there are some prohibitions covered under section 9(3) of the Trademarks Act, and those prohibitions or restrictions are called absolute grounds for refusal of registration. So any trademark found to be disqualified on the prohibitions or on the grounds of prohibitions covered under section 9, they shall not be registered at all. Another kind of a prohibition, another kind of grounds available for the refusal of trademark registration are covered under section 11, friends. We are done with the interpretation of section 9. We have seen it very exhaustively. We have covered certain case studies on section 9. Now our task here is to move to another important provision of the Trademarks Act 1999, that is section 11. And section 11, friends, provides some relative grounds for refusal of registration. When we try to analyze section 11, there are certain key concepts and key points that I would like to first of all elaborate. The very first point is that if you see the composition of section 11, it's a very widely worded provision. There are so many things covered under section 11 and so many prohibitions are given under section 11 which shall not be registered as a trademark. As the name suggests, friends, those prohibitions or grounds for refusal covered under section 11 are relative grounds for refusal of registration. It means that the trademark proposed to be registered by the applicant has to be seen relating it to the earlier trademarks existing in the market. If that trademark proposed to be used by the applicant is found to be impugned trademark or is found to be in contravention to the earlier trademark, is found to be deceptively similar to the earlier trademark, then that shall not be registered. Another key point before jumping to the language of section 11 and start analyzing the prohibitions covered under section 11 is about the concept of well-known trademarks. Well friends, section 11 of 1999 Act does involve well-known trademarks in its readings, or it talks about well-known trademarks in its readings. If we compare this 1999 Act Section 11 with the 1958 Act, the earlier repealed Act, Trade and Merchandise Marks Act, we do not find the concept of well-known trademark written over there. So is the case about the concept of, you see, similar goods written in the new Act, but on the other hand, in the 1958 Act, the word same goods were used. So you need to keep these two things in mind before jumping to the language of Section 11, that one, well-known trademarks are new incorporation in the language of Section 11, and instead of using the same goods or services, the one which was used in the 1958 Act, the new Act of 1999 uses the word similar goods, and that use of similar goods has changed the contours and interpretation of Section 11 altogether. One more thing that I would like to mention here at this juncture before starting reading Section 11 and its language is about its historical evolution. If we see Section 11, friends, we got the idea about this well-known trademark in the year 1925, when, you see, this Paris Convention was amended in the 1925. We became party or signatory to Paris Convention in the year 1998, and in the 1999 only we got well-known trademark idea incorporated in our law. But the point is, this idea came into the being in the year 1925 with the amendments that took place in the Paris Convention, and it got reflected in domestic legislation in the year 1999 when India became signatory to the Paris Convention in the 1998. Well, friends, I would now like to take you to the language of Section 11, which is little ticklish, but I'll try to make it very simple by giving you so many examples and illustrations. If you look Section 11 and its composition as on the screen, it reads, in the marginal note, it tells that these are the relative grounds for refusal of registration. If you see the very first clause of Section 11, it reads, a trademark shall not be registered if, because of its identity with an earlier trademark and similarity of goods or services covered by that trademark, or its similarity to an earlier trademark and the identity or similarity of the goods or services covered by the trademark, there exists a likelihood of confusion on the part of the public, which includes the likelihood of association with the earlier trademark. Well, friends, if you have a look closely of this provision, the language complicates lot of things. The use of the word, the frequent use of the words identity, similarity makes you little confused, but we can understand its purpose here by making it simple, especially when it comes to 11.1. We can understand that it is a case of use of identical or similar trademark on identical or similar goods. I am going to repeat it once again for your convenience. The prohibitions covered, or the prohibition covered under Section 11.1, friends, is a case of use of identical or similar trademark on similar or identical goods. And I have not dealt with the language of 11.2, but 11.2 in nutshell talks about use of identical or similar trademark on dissimilar goods. So one is a case of use of identical or similar trademark on similar goods, another is a case of use of identical or similar trademark on dissimilar goods. What is the bottom line now to be understood? That if because of this kind of a use covered under Section 11.1 and 11.2, there exists a likelihood of confusion on the part of the public, which includes likelihood of association with the earlier trademark, then that shall not be registered, because it may gonna free ride the reputation of the earlier trademark. It may gonna hamper the pace and purpose of the earlier trademark. As these are the relative grounds for the refusal of registration, and I told you in the very beginning that the later user's trademark has to be compared with the earlier user's trademark, has to be related with the earlier user's trademark. And when it has to be related with the earlier user's trademark, what is to be seen? It is to be seen whether the later user is trying to use a identical or a similar trademark on similar or identical goods, or is it trying to use a identical or similar trademark on dissimilar goods. In both the situations, the law is different altogether. In the situation of use of identical trademark on similar goods, the law tells that if there is a likelihood of confusion which includes likelihood of association, then it shall not be registered. Let us take an example of 11.1, and to understand 11.1, well friends, there is a earlier trademark, say A, available in the market on goods which are beverages in question. The trademark A is available in the market on beverages available in the market, or on the goods which are beverages. The later user proposes to get a registration with the identical or similar trademark of A on identical or similar goods, say on the beverages itself. Will he be able to succeed to get the trademark registration? The test given, the bottom line of this provision is to see whether there exists a likelihood of confusion which includes likelihood of association. If there exists a likelihood of confusion in this instance, it shall not be registered. If there does not exist any likelihood of confusion, it shall be registered. To understand it in a very clear manner, friends, you can understand that use of an identical trademark on similar goods is not allowed if that use is resulting into confusion, which includes likelihood of association. Why I am emphasizing so much on the likelihood of association? Let me tell you that this likelihood of association is a new insertion in the 1999 Act. In the 1958 Act, likelihood of association was not there. This was not a prohibition, or it was not a disqualification to be seen. It was added or inserted only with the 1999 Act, and with this insertion, the law has become more stringent, it has become more pervasive, it has become more, having more teeth in its implementation, because not only the confusion is checked by this law, rather the association or the likelihood of association is also to be checked and is to be seen. And here, with this likelihood of association thing, we understand the concept of dilution. We know the doctrine of dilution. We understand the doctrine of dilution. I'll take up dilution doctrine or concept later separately. But here, to understand and conclude the understanding of 11.1, I would like to say once again, and we will deliberate upon this interpretation again with some of the case studies to be provided by me, where I'll be telling you as to how later users sometimes try to use a deceptively or a confusingly similar trademark on the similar goods. And the word similar plays a very big role here. Had it been same, had the word been same, the interpretation would have been different. But now the similar word is used and identical word is used. With this usage, we get an idea that the law's purview, law's scope and ambit has been enhanced, because it does not only restrict the use of deceptively similar trademark or a confusingly similar trademark on same goods, rather it restricts the use on similar goods. In the example given by me of beverages, I would like to explain that I make soft beverages, and there may be a situation where one makes hard beverages. If he makes hard beverages, then his beverages are not same to my beverages, but they are similar, and there lies a likelihood of confusion to the mind of the consumer that these goods are originating from the same source, from the earlier trademark owner, and that is how the chances of confusion, the chances of getting cheated and duped are very high. So that is why you see section 11 in its purview and its ambit tries to restrict the use of confusingly similar and deceptively similar trademarks, which may gonna pose the tangible danger of confusion and association, not only in the case of similar or identical goods, rather by purview of 11.2, for the case of dissimilar goods also it restricts the use of a trademark and they shall not be registered. Well friends, we will discuss more and more on this relative grounds of refusal of registration provided under section 11 with the case studies and with more clear and elaborate manner in the next sessions. I rest here. Thank you very much.
With this note, thank you sir, thank you so very much for this productive session once again, and as he has already promised that we would be meeting again and would be discussing on some other topic under the series trademarks and copyrights. Very soon this lecture is going to be on YouTube for you. Watch this lecture, see this lecture the number of times you want it, and afterwards you can definitely send your queries, your feedback to us on info.cc@nic.in. We would be meeting again as I already said. Till then, take care, goodbye. Thank you sir, thank you so very much.